First day, the Kingdom of Spain against Infrastructure Service Luxembourg and the Milan against the Republic of Zimbabwe against the border development.
Mr. Basson.
My lords, my lady, I appear for Spain with Mr. Miles and Mr. Popplewell. For Zimbabwe, my learned friends, Mr. Mulan, Mr. Tompkins and Mr. Foxton. For the ISL parties, my learned friends, Mr. Green, Mr. Stafford, Professor Webb and Mr. Clark. And for the border timber parties, Mr. Harris, Mr. Keneally and Ms. Drummond.
Thank you.
My lords, my lady, I shall begin in relation to the ground A in these conjoined appeals, with the text and the nature of the obligation in Article 54.1 of the ICSID Convention. I shall then turn to make some points in relation to object and purpose and the supplementary means of interpretation. I shall then come to discuss some of the foreign judgments. I shall end by dealing with what we refer to as issues 3 and 4 in our written text, the additional points taken by the ISL parties in their notice of continuation. Coming then to ground A. The core of this issue, my lords, my lady, is the meaning of Article 54.1 of the ICSID Convention and the nature of the obligation that it imposes. If the court is with me that there is no submission to jurisdiction contained in Article 54.1, then that decides issue 1 as it has been presented in my written case. And in my submission, it is not a proper interpretation of that provision to say that Spain has submitted to the jurisdiction of English courts, and indeed that all ICSID member states have submitted to the jurisdiction of the courts of all other ICSID member states. I come then to my first point around the text and the nature of the obligation. Can we please start with the language of the Convention? It is at Joint Authority Bundle tab 191, and it begins at page 2827. The relevant provision is at 2845. And I'm sure there is already a high degree of familiarity with the first sentence in this provision. Each contracting state shall recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories, as if it were a final judgment of a court in that state. The court, of course, knows well the principles of treaty interpretation that apply. They are found in the familiar provisions of Articles 31 and 32 of the Vienna Convention. And there is a particular focus that one places on the text of the provision, a point that has been made by the House of Lords in Pinochet and the International Court of Justice in the Libya and Chad decision that I cite at paragraph 16 of my written case. On the text of Article 54.1, each contracting state has agreed to recognise and enforce ICSID awards within its own territories. The scope of the obligation undertaken by each contracting state is therefore limited to being within its territories. That territorial limitation is clear not only from the words within its territories, but also from the words at the end of the sentence, being as if it were a final judgment of a court in that state. The obligation of each contracting state is therefore linked to the courts of that contracting state, not the courts of any or other contracting states. And this point about the nature of the obligation is important. It is based on the text, but it clarifies that the nature of the obligation imposed by Article 54.1 is an obligation owed by each contracting state to all other contracting states. That much is not disputed. But in addition, the content of the obligation is limited to being within each contracting state's own territories. In particular, each contracting state has agreed to extend the jurisdiction of its courts to include claims for the recognition and enforcement of ICSID awards. And one can test this point against two scenarios, if I may. In scenario one, all contracting states could promise to all other contracting states to undertake conduct within its own territories. In scenario two, all contracting states could promise to all other contracting states to undertake conduct within each other's territories. These are different scenarios with different obligations. In both scenarios, the obligation is owed by each contracting state to all other contracting states. That's the point that's not in dispute. But in my scenario one, the scope of the obligation is limited to conduct within each state's own territory, while in scenario two, the scope of the obligation is extended to conduct in each other state's territory. The language of Article 54.1 shows that we are in scenario one, which in my submission cannot amount to an express submission to jurisdiction. And that is because scenario one is limited to a promise by a contracting state to undertake conduct within its own territories. A submission by that contracting state to the jurisdiction of other contracting states necessarily requires undertaking conduct in the territories of those other contracting states. Accordingly, my lords, my lady, when one reads the text of Article 54.1 and considers the nature of the obligation it imposes, it is clear that there is no submission by the contracting states to the jurisdiction of courts of all the other contracting states.
You said that submission to the jurisdiction of another state necessarily entails conduct in the territory of that other state. I mean, is that really right? Why can't you sit in your own territory and say, write a letter saying, which you don't post to the other side, you just put it up on your website and say, I submit to your jurisdiction?
Quite so, my lord, that the conduct for submitting to the jurisdiction of another contracting state's court will originate in the contracting state itself.
Right.
However, that conduct of submitting to the jurisdiction is felt and takes its effect in the jurisdiction of the other contracting state.
But it may, right, I was just quibbling with the way that you put it. That may not involve any conduct at all in the territory of the other state.
The positive conduct, you're quite right, my lord, may well be writing and posting a letter or putting a notice on a website or whatever it might be. But when I undertake the word conduct in that context, what I mean by that is that the actual submission to jurisdiction, which is the conduct I am referring to, is submission within proceedings occurring in the other contracting state. So I don't see it as a quibble, my lord, with wording, but rather just a pointer to it.
It used to be thought that a submission had to be in the face of the court, but that's gone.
Yes, my lord.
So there's no reason why you can't have a submission which does not involve conduct in the state, in the other state, as my lord says.
My lord, the concept of conduct in this sense is not one where, in my respectful submission, the court would analyse precisely where the location of the author of the document of submission is located or where they sent the email from. By conduct in this sense, I take the point rather more broadly to mean that where there is submission to jurisdiction, the courts of another contracting state, that is what I refer to as the relevant conduct. Something is required to be done in the courts of the other contracting state. I have chosen to label that as conduct, to keep a neutral term as I sought to use, but I'd be very happy for that to be regarded as a form of submission in a legal sense. That, in my submission, is still conduct in the territory of the other contracting state, but it is the legal act of submitting to the jurisdiction of the courts in the other contracting state that takes place in the territories of that other contracting state. And that is why submission to jurisdiction...
Sorry, just on that, I mean, why isn't it just something of which the court takes cognizance? You know, the notice posted on the website in the territory of the state which is submitting. I mean, I'm just struggling with the idea that that's conduct in the territory of the other state. I mean, it almost seems to boil down to, well, the court is sitting in the territory of the other state. It takes cognizance of this event, and and then you sort of say, well, we'll give that the label conduct by the submitting state in the courts of the other state, whereas there doesn't seem to be any reality to the conduct of the submitting state happening in the territory of the other state. It's just that the courts of the other state take cognizance of an event that's happened elsewhere in the world.
My Lord, respectfully, I would suggest that it is more than simply taking cognizance. And the reason for that is that what transpires when the other contracting state submits to the jurisdiction of the host state or the state of jurisdiction is that the other contracting state is waiving its immunity that exists under a statute in this jurisdiction. So it is waiving its immunity under Section 1.1 of the 1978 Act. And that
you're now, sorry to interrupt you, but just so I get it clear, you now seem to be, you switched from ICSID to the State Immunity Act. You're talking about the UK specifically.
So I'm taking the UK as an example, yes, my Lord, and the reason why I'm taking that as an example is that because of the existence of adjudicative immunity under Section 1 of the Act, a court in this jurisdiction is not simply taking cognizance of an act that occurs overseas. Rather, it is a submission to the jurisdiction by that other contracting state involving a waiver of a statutory right that it has, that this jurisdiction has described as a right of the greatest importance. So the analysis, if I may respectfully suggest, of where the physical act of submitting to the jurisdiction by posting the relevant document to the commercial court or expressing the written form in which the submission takes being overseen does not take the analysis forward. Ultimately, the effect of what is being done is felt and has legal consequence and involves a waiver of an important right within the jurisdiction of the state where the courts are exercising jurisdiction.
But it can be done by entering into a treaty.
My lady, yes, it can, in those circumstances, be done by entering into a treaty. I don't resile from that. However, in entering into that treaty, and we can see the language of some treaties that do, what that state is doing in that form is submitting to the jurisdiction of the state where the courts are exercising jurisdiction. So by whatever form, entering into a treaty or a contract, sending an email or filling out the relevant form from the commercial court website, ultimately that is still a submission to the jurisdiction, in this jurisdiction, of English courts. And that is where the legal effect and legal consequence is felt. That is where the important right in Section 1.1 of the 1978 is waived. So in those circumstances, there needs to be some form of impact, which I referred to as conduct in my earlier submissions, within the territories of another contracting state under the ICSID Convention. What our discussion cannot be is conduct which is limited within the territories of the submitting state. Any of the examples that we use, whether it be by treaty, contract, or some other form, still have a legal effect and consequence and a waiver not within the submitting state's own territories. That, therefore, is a scenario 2 obligation that is being fulfilled. That's a scenario 2 obligation that one would interpret Article 54.1 as containing. In my submission, that is not an accurate interpretation of Article 54.1. The language of Article 54.1, on its plain text, is clear that the scope of the obligation on each contracting state is limited to within its territories. And by whatever form a submission to jurisdiction in another territory is made and takes effect, that is not within the scope of an obligation limited to within its territories. One also sees this point illustrated not only by the text that is found within Article 54.1, but also the text which is not in Article 54.1. When one reads that provision, there are no words that would naturally express a waiver of immunity or submission to jurisdiction. The terms waiver, immunity, submission and jurisdiction are not found in the provision. And that's important because when states waive immunity in foreign domestic courts, those are the terms that most naturally express that waiver of immunity.
Well, arguments that something could have been expressed in a different way are not usually very powerful arguments of interpretation. You could always say that the provision doesn't say X. If it did, no doubt that we wouldn't be here having 2 days arguing about what this sentence means.
I completely take my Lord's point. And I don't put this point about text that is not used any higher than to say that the words that would be most naturally occurring in order to waive immunity or submit to the jurisdiction are not contained in the ICSID Convention. And the reason why I highlight the point about language that is not in the text is simply because previous decisions, including by the House of Lords and by the International Court of Justice, have pointed out that the absence of that language, and in particular, the language of waiver of immunity, is an aid to the interpretation of a provision. My Lord, Lord Legate is correct that, in a general sense, the absence of language from a particular contractual, statutory, treaty clause is not going to aid discussion very much. But we are not talking here about ordinary or humdrum language. We are talking here about a waiver of state immunity, which courts in this jurisdiction have repeated time and again as being a matter of the greatest importance. So to the extent that an analogy might be drawn with the absence of language in an ordinary commercial contract as being an aid to interpretation of that contract or not, with respect, that is not a helpful analogy. Here, in circumstances where it is suggested that the contracting states to the Convention have waived immunity, and they have done so tacitly, in circumstances where the International Court of Justice has said a tacit waiver of customary international law rights ought not to flow with ease when interpreting a text. In my submission, the absence of the words waiver, immunity, and submission to jurisdiction are meaningful when interpreting Article 54.1. I won't take the court to all of the examples, but in my written case at paragraph 27, the court will have seen that we have listed a number of treaties where this express language of waiver of immunity and submission to jurisdiction is used by states. The example that, in your notional spare time, I might encourage the court to look at is that of the Southern African Development Community Protocol on Finance and Investment. I might use my own notional spare time during these submissions, actually, to take the court to it, just very briefly. Could we please turn up the Joint Authorities Bundle at tab 190?
We're all working off electronic copies, Mr. Bassett, if it helps. So we will only need the electronic page reference, but it may be that Council may be working off hard copies, so they will need the tab reference as well.
I will be as Catholic as possible in my referencing, my Lord.
So we're going to page?
The page will be page 2825.
Thank you.
And one can see at the bottom of 2825, Article 12, in this annex to the protocol that I referred to. And I don't plan to dwell long on this, but simply to say that when one looks at paragraph A, B, and C in Article 12, this is the type of language that one would naturally expect to see, constituting a waiver of immunity and a submission to jurisdiction. My Lord Legate is absolutely right that there is a limited distance I can take this point, but in circumstances where this is not a point in relation to ordinary commercial contracts being construed, the absence of similar language to what we see in the SADC Treaty from the language in Article 54.1 of the ICSID Convention, in my submission, is meaningful. What we see in Article 12 here is what a waiver of adjudicative immunity or a submission to jurisdiction looks like in its most naturally expressed form. The nature of this obligation that is undertaken in Article 12 is my earlier scenario 2, where the scope of the obligation extends beyond the territory of the contracting state. That is, it is a waiver of immunity of the defendant state party before the courts of another state. In my submission, that is markedly different language to Article 54.1, which does not contain a scenario 2 obligation. Now, the importance of words used and indeed not used has been emphasised previously in the Pinochet decision. Pinochet, obviously a very well-known decision, concerned the interaction of another multilateral treaty, the Torture Convention, with the English law of state immunity. I'd like just to go to the Torture Convention itself, if I may. That's in the Joint Authorities bundle at tab 180, page 2763.
Mr. Bastin, I don't want to take you out of your order, but at some point I'm going to need some help in relation to the term express and where it comes from, because express is not in Section 2 of the State Immunity Act, although it is in the UN Convention and it is in the European Convention. It's not in the US Foreign Sovereign Immunities Act. Yes. I think it's suggested that it may be common ground, that there is a requirement that the waiver be express, but I'd like some help on that at some stage, please.
Very happy to, my Lord. I would take that in the course of my submissions about Pinochet, because the short answer to your question is that it is agreed by all parties to these conjoined appeals that the submission needs to be express, and the origins of that requirement are really taken from Pinochet and the speeches of their lordships there, perhaps with most focus on the speech of Lord Gough.
Which is a dissenting speech.
Oh, pardon me, and Mr. Popper reminded me it's also used in Lord Millet. And in relation to my Lord Lloyd-Jones' point that Lord Gough's speech was a dissenting speech, that is correct on the primary point on which the House of Lords decided Pinochet. But on this point, about the existence of a waiver, Lord Gough was not a dissenting speech. Rather, in that instance, it was Lord Savile that was dissenting on this point. So in relation to the existence of a waiver, difficult though I know it can sometimes be to pick through all the different speeches in Pinochet, when one does so, on this point, Lord Gough is not in the dissenting posture. I will come back to this point if I may, my Lord. But if I can just take the court first to the Torture Convention itself, it's in the bundle at page 2763. And I will start with Article 4, which is over the page on 2764. I'm glancing over your shoulders as I expect the operation of the bundle is being done from the back row. Now, Article 4, or if not, I will make sure I pause to allow it to be done. Now, Article 4 is the agreement by the states parties to the Convention that they will criminalise offences of torture. Article 5 then takes the point further. It requires each state party to take such measures as may be necessary to establish its jurisdiction over the offences referred to in Article 4, in certain cases which are listed there, including in cases where the alleged offender is present in any territory under its jurisdiction. And if one then reads Article 7 over the page at 2765, that requires that the state party in the territory under whose jurisdiction a person alleged to have committed any offence referred to in Article 4 is found, shall, in the cases contemplated in Article 5, if it does not extradite him, submit the case to its competent authorities for the purpose of prosecution. Again, the nature of the obligation in the Torture Convention is to take steps within each state's own territory. That's what I have called Scenario 1. And it refers to the jurisdiction of that state party's own courts within its territories in both the language of Articles 5 and 7. Now, I'm not going to turn through all the speeches in Pinochet in order to explain the reasoning on both the primary case and then also on the secondary case of waiver, as my learned friend Mr. Moulin will do so this afternoon. But what I do emphasise now, including in response to the question from my Lord Lloyd-Jones, is what the House of Lords reached by way of decision on the waiver point. It was held that the agreement in the Torture Convention to prosecute public officials accused of torture did not waive immunity from jurisdiction under English law. The essence of the reasons on that waiver point was that the waiver had to be express, which, as I've said, all parties to these appeals agree is a requirement. And the language used in the Torture Convention, and indeed not used, was insufficient to waive the adjudicative immunity that vested in Chile. Now,
so are you going to give us the bundle references for Pinochet?
I can, my Lord. I was not planning to spend much time on it.
No, just have the references would be useful. You don't need to take up time if you don't want to.
I'm grateful, my Lord. The reference for Lord Gough is at bundle reference tab 58, pages 799 to 800, internal page reference 216H to 217D. And that is where Lord Gough makes the point that my Lord Lloyd-Jones asked about. He says there, Section 2.2 recognises that a state may submit to the jurisdiction by a prior written agreement. So quite right, my Lord, to say that there is no reference to the word express in Section 2.2, as Lord Gough accepts in that starter to his sentence here. But then Lord Gough continues, which I read as referring to an express agreement to submit. There is no suggestion in the Act that an implied agreement to submit would be sufficient, except insofar as an actual submission to the jurisdiction of a court of this country may be regarded as an implied waiver of immunity. But my reading of the Act leads me to understand that such a submission is here regarded as an express rather than implied waiver of immunity or agreement to submit to the jurisdiction. It appears to me to be clear that, in accordance both with international law and with the law of this country, which on this point reflects international law, a state's waiver of its immunity by treaty must always be express. The reference to Lord Millett is at internal page 268C, bundle page 851.
Thank you.
851.
851, my Lord.
I'm sorry, could you have that reference again, please?
Yes, my Lord. The reference to where Lord Millett makes the same point about an express waiver is at internal page 26C on bundle page 851.
Thank you.
Spain's interpretation of Article 54.1 is, with respect, consistent with the House of Lords' position in Pinochet. And this is a point which the Court of Appeal below, to whose judgment I will come to later in my submissions, did not engage with. In my respectful submission, if there is to be an express waiver of immunity or submission to jurisdiction, as all parties agree there must, it is Spain's interpretation of Article 54.1 that aligns with that position. Now, against me, on that point of text, the respondents to the appeals read Article 54.1 in a particular way to say that it is a submission to the jurisdiction of other contracting states' courts. Again, the court may not need to, but if one goes back to Article 54.1, that's at bundle page 2845, tab 191. And the respondents read this sentence as a submission to the jurisdiction of other contracting states' courts because, in their language, each contracting state has consented to all other contracting parties exercising jurisdiction over them. One can see that in issue 1 in the statement of facts and issues filed in each appeal, page 16 in the Spain appeal, page 6 in the Zimbabwe appeal. So the respondents in effect say that Article 54.1 is a scenario 2 obligation. All contracting parties promise to each other to do something within each other's territories. 2 points that I make here. The first is that this is not what Article 54.1 says, or indeed the type of obligation that Article 54.1 imposes. I've already explained my submissions on the proper interpretation of the text, and importantly, the nature of the obligation that the provision imposes. I won't repeat those points. I simply note on that textual point that Article 54.1 does not say consented to, and is not the natural reading of the words to read those in and find a waiver of immunity. After all, simply because the contracting party signs a treaty and assumes an obligation, it does not follow that all other contracting parties needed to consent or have consented to that contracting party undertaking the obligation. It's illustrated in the context of the ICSID Convention in circumstances where a contracting party can join that convention without the express consent or invitation of the other contracting parties. The court requires it. That is in Article 67 of the Convention, which simply states in its first sentence, this convention shall be open for signature on behalf of state members of the bank, meaning the World Bank. Article 54.1 is a scenario 1 obligation. States can create scenario 2 obligations, as we have seen in the SADC Treaty, but that is not what Article 54.1 does. My second point on the respondents' consented to argument is that even if one adopts the view that Spain had consented to other contracting states taking on an obligation to recognise and enforce ICSID awards, that still does not mean that Spain submitted to the jurisdiction of English and other contracting parties' courts. These are two very different points and indeed concepts in international law. Now please take the court to the decision of the International Court of Justice in arrest warrant. That is that supplementary bundle, tab 8, at page 96. Now, the court may well be familiar...
Bear with us just a moment, if you would, please.
Pardon me.
Is this the first supplementary?
Correct, my lady, yes. while the court finds it, I'll just remind the court that the question in that case was whether an arrest warrant issued by Belgium against the Minister of Foreign Affairs of the Democratic Republic of the Congo violated international law by infringing on the minister's immunity from criminal jurisdiction.
Please.
I will pause while the technology comes into line.
I'm sorry, don't worry.
Not at all.
Only I hope take a moment. Thank you very much. I'm sorry about that.
I'm grateful. Now, the court held that incumbent foreign ministers are fully immune from criminal jurisdiction in other countries, regardless of the charges, in that case the charges being war crimes and crimes against humanity. If one turns to page 119 in the bundle at paragraph 56 of the judgment, that is where one sees Belgium arguing that the immunity of incumbent foreign ministers cannot protect them when they are charged with war crimes or crimes against humanity. That point was rejected over the page at paragraph 58. But the point that I wish to emphasise for the purposes of these appeals appears in paragraph 59 at the bottom of bundle page 120. There the court says, "It should further be noted that the rules governing the jurisdiction of national courts must be carefully distinguished from those governing jurisdictional immunities." Jurisdiction does not imply absence of immunity, while absence of immunity does not imply jurisdiction. Thus, although various international conventions on the prevention and punishment of certain serious crimes impose on states obligations of prosecution or extradition, thereby requiring them to extend their criminal jurisdiction, such extension of jurisdiction in no way affects immunities under customary international law, including those of ministers for foreign affairs. These remain opposable before the courts of a foreign state, even where those courts exercise such a jurisdiction under these conventions. An important statement of international law from the International Court of Justice, which is analogous here. Article 54.1 requires states to extend the jurisdiction of their courts so as to be able to recognise and enforce ICSID awards. But that extension of jurisdiction must be carefully distinguished from the existence or waiver of a jurisdictional immunity held by a state. Indeed, it is important to note that paragraph 59 is expressed at a level of principle. It talks about jurisdictional immunities generally, as they exist under customary international law. Indeed, in this paragraph, one could simply replace references to extending criminal jurisdiction of national courts with references of extending jurisdiction to allow recognition and enforcement, and replace the references to foreign ministers with references to foreign states. And then that principle disposes of the respondent's consented to argument in these appeals. Can we please just read on in arrest warrant to paragraph 60 and 61, now on bundle page 121. In paragraph 60, the court identifies how immunity is not impunity. It says in the middle of that paragraph, immunity from criminal jurisdiction and individual criminal responsibility are quite separate concepts. So it's recognising that jurisdictional immunity can pose problems. It can potentially encourage, at least in the relevant jurisdiction, immunity. And you see the court reflecting on those problems in paragraph 61. It says at the start of 61, the immunities enjoyed under international law by an incumbent or former Minister of Foreign Affairs do not represent a bar to criminal prosecution in certain circumstances. So this is the way through the otherwise principled basis that the existence of jurisdiction does not imply a waiver of immunity. And the solution is not to pretend otherwise, to collapse fundamentally different concepts of international law. The solution is given in the second, or the paragraph beginning secondly, in paragraph 61. Secondly, they will cease to enjoy immunity from foreign jurisdiction if the state which they represent or have represented decides to waive that immunity. So jurisdictional immunities are not obviated by saying a treaty has a waiver implicit in it when on its plain terms it does not, but rather it is obviated by the relevant state waiving that immunity. Waiving immunity requires something more in the logic of arrest warrant. It is not sufficient to just identify in the terms of a treaty the existence or the extension of a domestic jurisdiction over particular subject matter in that treaty.
Unless the treaty is read to cover scenario 2.
Unless the treaty is read to cover scenario 2, my lady, that's quite right. And of course, based on the text of the provision, but also some of the points I'll come on to make shortly about object and purpose and supplementary means, Spain says there is no basis on which Article 54.1 could be read to constitute a waiver of jurisdictional immunity.
I mean, might it not be said that the Torture Convention is addressing absolutely anyone who may have committed torture, and then obligations are imposed on states where they're found to arrest them and either to prosecute or give them up for prosecution. Whereas Article 54 of the ICSID Convention has a much more specific focus. And I mean, I appreciate you're going to come on to object and so on, but I'm just putting the point to you now that Article 54 appears in a treaty, it might be said, the whole point of which is to make states responsible and actually responsible for obligations under investment treaties and to introduce an enforcement mechanism in relation to that. So the focus is very much narrower and more specific than it is for the Torture Convention.
I think there are a number of points arising out of my Lord Sayles' question. The first is that one needs to be careful, no matter the number of potential defendants in a jurisdiction that a treaty obligation might affect in relation to the extension of the domestic jurisdiction in that state, not to undermine the importance of the distinction between the subject matter of the treaty and the extended jurisdiction of the domestic court, and the existence and waiver or not of the jurisdictional immunity of the relevant defendant from that jurisdiction. That distinction is important for the reason that I give in arrest warrant. So even if one treaty, the Torture Convention, could potentially be relevant in proceedings against a very large number of individuals who might be caught by its terms, an alternative treaty may only be relevant to a very limited number of defendants that might be caught by its terms. That does not change the starting point from being the important point of principle highlighted by the court in arrest warrant. Even if a treaty were to extend jurisdiction of a domestic court in relation to a single possible defendant, that would still be a different question which has to be very carefully kept separate from the question of whether that defendant would have a jurisdictional immunity from the proceedings before that domestic court. Indeed, my Lord, on a reading of the Torture Convention, in my submission, it would not be a case where there would be a very large number of potential defendants. Torture can only be committed officially. So in those circumstances, state immunity will always be engaged. It can only be in the official conduct of a senior state official. So the in personam scope of who may be defendants in relation to that extended domestic court jurisdiction is actually reasonably limited. By contrast, ICSID awards are not just enforceable against states. Indeed, the primary purpose, as we will see in Article 54.1 of the Convention, was to allow enforcement of ICSID awards against investors. So in those circumstances, Article 54.1, in my respectful submission, is not a much more limited obligation in terms of its potential application to a certain number of defendants compared to the Torture Convention. The second point that I've touched on that arises out of my Lord S.A.R.L's question is what the animating purpose behind Article 54.1 was. I will come to this in more detail when I come to my points on supplementary means. But as I touched on, Article 54.1 had as its principal purpose a benefit for the contracting parties to the ICSID Convention, i.e., that it would give them a mechanism to enforce ICSID awards against investors that had lost an arbitration or maybe had some form of order against it. I'll come to that in more detail.
I find it very difficult to see how you can read it as intended to be operate in one direction.
My Lord,
surely it's intended to work both ways, and that's the whole point generally of the Convention. You must read it in a balanced way, not in a way that favours the state or the investor.
my Lord, quite so. I don't resile from that at all.
Good.
And the it's always nice to have a moment of agreement. But the interpretation that Spain advances is not that the first sentence of Article 54.1 only benefits contracting states, but rather that when one is interpreting it, one looks to the text, and there is no submission to jurisdiction there, and then one may confirm the meaning of the text by reference to supplementary means of interpretation. And when one goes to those supplementary means, as I will come to shortly, what is evident is that during the discussions and negotiation of the text of the Convention, the preoccupation was to ensure a mechanism that allowed the contracting parties to enforce awards against investors. Now, it says in the Travaux Préparatoires that Article 54.1 may have other uses as well, exactly as my Lord Legate anticipates. But what one does not find in the Travaux Préparatoires is even a trace of a suggestion that Article 54.1 was a submission to the jurisdiction by each contracting state to all other contracting states. And that, my Lord Legate, is the important point. That is the point which confirms the interpretation that Spain advances in relation to Article 54.1. Not an interpretation that they get a better ride than investors, not at all. But rather an interpretation that does not see in the text of Article 54.1 a submission to the jurisdiction of all other contracting states.
I mean, speaking of myself, I slightly question whether it's not there in the text itself, because I mean, this is a convention to which a contracting state necessarily has contracted. So why shouldn't one read it as each contracting state saying, I agree that you, other contracting states, shall recognise an award against me as a contracting state, and therefore accept that that should be enforced?
My Lord, on the face of the provision, I can understand why the respondents advance that point. But there are two reasons why one ought not, and in my respectful submission, cannot, read Article 54.1 in that way. The first is that that way would require that those contracting states accept that they have no adjudicative immunity before the courts of all other contracting states. As this court has previously held in the Mikula decision at paragraph 105, the ICSID Convention did not seek to harmonise all the various laws on state immunity around the world. And as such, if that was not the purpose of Article 54 of the ICSID Convention, in my respectful submission, it is not possible to read Article 54.1 as a submission to the jurisdiction, as an agreement by all contracting states that they would waive all immunity before other contracting states. The second point in relation to my Lord Sales.
So sorry, do you have a bundle reference? It's just helpful for us.
I do. They are
don't invite you to turn it up.
I'm grateful, my Lord. They're in my notes, but you're putting me in that typical advocate's position of flicking through to find the bundle reference.
Right. But don't worry about that.
But it's Mikula paragraph
105.
105. Thank you.
I can see fingers flying on keyboard, so I don't think
but please go on, don't take up time on it. Well, I'm sure
but how would my Lord's mutual obligation to enforce awards in other states, that the agreement that other states would recognise and enforce awards against the submitting state, how would it work if immunity if adjudicative immunity was preserved?
My lady, I'm very grateful for that question, because that was the second point that I was intending to come on in relation to my Lord Sales's question. Reference is 548. Oh, I'm grateful to Mr. Green. The reference to Mikula 105 is page 548 of the Joint Authorities Bundle.
Thank you very much.
I'm grateful. So in relation to my Lady Simler's question, the way it works is that Article 54.1 requires contracting states to put in place a mechanism by which ICSID awards can be recognised and enforced. And that includes a mechanism by which the adjudicative immunity that the respondent state in the arbitration would otherwise normally benefit from could be put aside. And that is exactly what the United Kingdom did in this case. I will skip ahead in my notes to locate where this is, because it comes with exceeding clarity from the records of Hansard when the 1978 Act was drafted. And if we can go to
if you're going to take us to Hansard, we need to know precisely for what purpose, any more context.
Quite so, my Lord. And the reason I'm taking the court to Hansard is because it is said that there is a putative ambiguity through Section 2 of the State Immunity Act arising from the interpretation of Article 54. And Hansard records a statement at ministerial level by the Solicitor General as to exactly what mechanism the United Kingdom was establishing in order to allow for the recognition and enforcement of awards issued under the ICSID Convention, including in order to find a route through the adjudicative immunity of the respondent state in the arbitration.
Do you say this casts light on Article 54 as opposed to Section 2?
Pardon me, my Lord.
Do you say this casts light on Article 54 as opposed to Section 2?
It casts light on what the United Kingdom was understanding it was doing when creating a mechanism for the recognition and enforcement of ICSID awards in circumstances where there was Section 1 immunity and the Solicitor General needed to explain the way in which an ICSID award could be recognised and enforced through one of the exceptions to that immunity in the State Immunity Act. Now, my Lord, maybe the easiest way is to show the court, Hansard. It's that Joint Authorities Bundle, tab 218, at page 3159.
I'm so sorry, just as we're looking it up, I'm struggling a little bit with the idea that you get ambiguity in section 2 arising from the interpretation of an international convention. I mean, I would have thought that section 2 is either ambiguous or not ambiguous on its own terms. I don't... just help me. How do you make it ambiguous by referring to an international convention?
The question is whether the test for submission in section 2 has been satisfied, and it's satisfied or not in this case by reference to Article 54.1, my Lord. That was the extent of my point in relation to my Lord Lloyd Jones's question.
But if you're relying on Pepper and Hart to construe section 2 by reference to Hansard, then what does Article 54 have to do with it?
Well, and the reason is, my lady, that when the State Immunity Act was being drafted, the Solicitor General explained the route through the state immunity, through the Section 1 immunity, by reference to Article 54.1. So the reason why I'm saying that this is permissible under Pepper and Hart is that it is said against me that there is no submission to jurisdiction under Section 2 of the Act, and it is also said against me that there is an arbitration agreement under Section 9 of the Act. Pardon me, it was said against me that there is a submission to jurisdiction under Section 2, and there is an arbitration agreement under the Act. And so for those reasons, in order to interpret whether or not that is satisfied, as the Court of Appeal below did, it is appropriate to look at what was said in Hansard.
I can't see how that resolves any ambiguity in relation to Section 2.
It may well be, my Lord, that the ambiguity ultimately arises out of Article 54.1.
Indeed.
And whether or not that is sufficient for the purpose of Section 2 and indeed Section 9 of the State Immunity Act. In those circumstances, it is appropriate to look to Hansard. Indeed, that is also consistent with the position under international law, where supplementary means of interpretation are entirely appropriate in order to look at the meaning and confirm the meaning under a treaty. So whether one looks at the lens of this through Pepper and Hart or through Article 32 of the Vienna Convention, the record of Hansard is appropriate to consult. And if we can turn up, please, the reference at Joint Authorities Bundle, tab 218, at page 3159, one can see what the Solicitor General was understanding at that point. There at the bottom of column 9, on the left, one sees the Solicitor General pick up the point. Here, there is discussion of Clause 9 of the draft bill, which would become Section 9 of the Act.
Yes.
At the very bottom of the page, it begins, Clause 9 provides that where a state has agreed in writing to submit a dispute to arbitration, the state is bound by its agreement so that it is not immune in respect of proceedings which relate to that arbitration. I doubt that anyone would dissent from that as a reasonable proposition. But at present, that provision is limited to arbitration in or according to the law of the United Kingdom. So if the clause remained unamended, states would continue to be immune from enforcement proceedings in respect of foreign awards or convention awards, even where they had agreed in writing to submit to the jurisdiction. He then makes remarks about the European Convention. But then he continues about a third of the way down column 10. There is an additional reason. Article 54 of the ICSID Convention, which is to be found in the schedule to the 1966 Act, states, and then he quotes the language we're familiar with from Article 54.1, that convention is an additional reason. Pardon me, that convention deals with arbitration to which states are parties. There would thus appear to be a treaty obligation upon us to permit awards made under the Convention to be enforced against such property, and by deleting the reference to the United Kingdom or its law, the amendment will ensure that a state has no immunity in respect of enforcement proceedings for any foreign arbitral award. So with respect, it is clear that the route past immunity under Section 1 of the 1978 Act, when enforcing an ICSID award, was meant to be Section 9. If there were already a route past immunity in Section 2 of the Act, or indeed somewhere in the 1966 Act itself, to enforce ICSID awards, this exchange would have been redundant. There would have been no need to amend Clause 9 to allow ICSID awards to be enforced, as there was a submission to jurisdiction in Article 54.1, or immunity was somehow otherwise dispensed with by the 1966 Act. My respectful submission, that is a clear indication by the drafters of the 1978 Act that one is to regard the exception to Section 1 immunity for enforcement of ICSID awards to be found in Section 9. They did not see a submission to the jurisdiction of English courts in Article 54.1. The last point that I wish to make in relation to my Lady Simler's question, in relation to how does a claim against states work, is that if there is to be a claim against a state for a breach of the Convention, the Convention makes separate provision for that beyond what is found in Article 54.1. So if there is a breach by a state of its obligations under the ICSID Convention, then there may well be a claim against it before the International Court of Justice, which is known as a diplomatic protection claim. The relevant provisions in the ICSID Convention are found in Articles 27 and 64. If I can come back to where this discussion with my lords and my lady began, the point that I was making arising out of arrest warrant is that simply because a provision in a treaty extends the jurisdiction of the domestic legal process of contracting parties to that treaty, that does not imply that there is a waiver of immunity to allow that jurisdiction to operate in a particular way. Now, the court may have seen that the supplementary bundle, the first one, is populated in largest part by additional authorities from the respondents, a number of which concern discussions about different categories of immunity under international law, sometimes foreign official immunity, sometimes diplomatic immunity, sometimes state immunity. If it is the case that the respondents say that immunity from criminal proceedings for foreign officials has a different scope or nature to adjudicative immunity of states to civil proceedings before the domestic courts, I have 2 points on that front. The first is that submission is with respect misplaced. There is no basis for dancing on the head of a pin between the different categories of state immunity and foreign official immunity. The requirements for submission or waiver are the same in each case. That is, the submission must be in writing, express, and given by the state concerned. And the general application of the principle that we saw in paragraph 59 of arrest warrant has been confirmed in the leading text on state immunity in this jurisdiction, authored by Lady Fox and Professor Webb. That is in the supplementary bundle at tab 19 at page 349. And if we can turn it up, you'll see there that this is the chapter that the authors have generated on the 2004 UN Convention. The relevant provision is Article 7. And this is where the authors are discussing how the International Law Commission, when drafting the UN Convention, regarded the waiver by a state of its adjudicative immunity by treaty. And it's towards the bottom third of the page at page 351 of the first supplementary bundle. There the authors say, the emphasis, in relation to consent to the exercise of jurisdiction, which was dealt with in Article 7, they say the emphasis is on express consent with regard to the matter or case. Waiver of immunity and consent to the exercise of jurisdiction in respect of a state cannot be inferred by mere implication from a provision in which the state agrees to exercise jurisdiction over certain activities. The authors then go on to quote the very paragraph from arrest warrant that we have looked at. It is in my submission plain that the principle that we have seen in arrest warrant applies to the waiver by its state of its adjudicative immunity by treaty and is not limited only to waiver of foreign official immunity in criminal proceedings. And indeed, just to complete the circle, the International Law Commission itself, following its work leading to the draft 2004 UN Convention, confirms this point. Subsequent to that convention, the ILC drafted articles on immunity of state officials from foreign criminal jurisdiction. And for each of those articles in the usual way, the ILC has a particular commentary. I'd just like to show you the commentary to the relevant...
Just before we move on from this, I mean, this is focusing very much on state agreeing to exercise jurisdiction over certain activities. And the reference, I think, is to the Torture Convention again. That's the context for the arrest warrants case. Might it not be said that Article 54 is not referring to taking jurisdiction over particular activities, but an exercise of jurisdiction in relation to certain events, namely an award being made against the particular state, against the other contracting state?
With respect
so that's not an activity of that state. It's true, it implies that that state has engaged in certain activities in the past, namely participating in the arbitration.
And your last point there, my Lord, rather anticipated the answer I was going to give, which is that with respect, it would be too fine a distinction to say that jurisdictional immunities kick in relation to the exercise of jurisdiction over certain activities, such as those covered in the arrest warrant, which relate to war crimes and crimes against humanity rather than a breach of the Torture Convention, but does not kick in relation to the recognition of enforcement of ICSID awards. As your Lordship indicated, such recognition and enforcement does follow certain activities, which is the conduct of the arbitration. And the International Court of Justice, at paragraph 59 of arrest warrant, is very clear as to the statement of principle. It refers to jurisdictional immunities, full stop. It does not refer to immunity arising from certain activities. And it says that in relation to the rules governing the jurisdiction of national courts, those rules must be carefully distinguished from those governing jurisdictional immunities. As it said, the presence of one does not imply the absence of the other. So in those circumstances, the statement of principle applies to jurisdictional immunities, and certainly it applies to those jurisdictional immunities that are different species of state immunity. Foreign state official immunity, of course, arises as a species of state immunity and is treated as such by the definition of the state in, I believe, it's section 14 of the 1978 Act. So with respect to the suggestion that there may be a way to thinly slice and separate out different types of jurisdictional immunities that paragraph 59 of arrest warrant is referring to, in my submission that is not possible, is not a reading of paragraph 59 that is correct, or indeed emerges clearly from Lady Fox and Professor Webb's chapter. Can I just show you then where the ILC got to in its programme of work around the immunity of state officials from foreign criminal jurisdiction, which followed the drafting of the 2004 UN Convention. And if we can go to Supplementary Bundle 1 at page 384, tab 21. This is page 384 is the start of the relevant ILC document, and its commentary on the relevant article, which is Article 12, begins at page 384. And you can see there, in paragraph 2, it refers to waiver of immunity must always be express and in writing. The commentary to draw attention to is at paragraph 8 on bundle page 387. There, the ILC comments that the requirement that the waiver be express has been consistently reaffirmed by the Commission in its previous work and is reflected in both relevant treaties and national laws. For this reason, the Commission did not retain paragraph 4 of the draft article originally proposed by the Special Rapporteur in her 7th report, which was worded as follows. A waiver can be deduced clearly and unequivocally from an international treaty to which the forum state and the state of the official are parties, shall be deemed an express waiver. While members of the Commission generally considered that the waiver of immunity may be expressly provided for in a treaty, there was some criticism of the use of the phrase can be deduced, which was understood by some members as recognising a form of implicit waiver. So the ILC, in the context of what had come before, including indeed arrest warrant at paragraph 57, was clear that a waiver cannot be deduced. That is consistent, of course, with Spain's case that we put forward on Article 54.1. Before leaving the consented to argument that is advanced by the respondents in these appeals, there is another repackaging of that point that I ought to address. This is the point based on NML and Argentina, the previous decision of this court. Now, the respondents suggest that the language of Article 54.1 in the ICSID Convention is strikingly similar to that found in the contractual term in the bonds at issue in NML and Argentina. But with respect, that is simply not so. If we can go to NML, it is behind tab 49 in the Joint Authorities bundle, so the main bundle, and we pick it up at page 599.
599?
599 in the main bundle.
Main bundle.
Yeah. No, I'm in the right bundle. Yes.
Now, this is the full language that the court was looking at, albeit it doesn't have the title of the provision which was being considered, which referred to in the title waiver of immunity. But if we can pick up the last sentence in the first paragraph of the bond language at the top of 599, one sees there the language in the bond is that the Republic, Argentina, agrees that a final non-appellable judgment in any such related proceeding, the related judgment...
I'm sorry, you're reading from page 599, which paragraph?
Just above C in the side column, my lord. It's 599 of the main authorities bundle.
So the first words are?
The first words are, the Republic agrees that a final non-appellable judgment, I'm grateful, in any such related proceeding, the related judgment, shall be conclusive and binding upon it, and may be enforced in any specified court or in any other courts to the jurisdiction of which the Republic is or may be subject, the other courts, by a suit upon such judgment. It then continues, to the extent that the Republic, or any of its revenues, assets or properties, shall be entitled in any jurisdiction in which any specified court is located, in which any related proceeding may at any time be brought against it or any of its revenues, assets or properties. And this is the language that was highlighted in the court's judgment in NML. or in any jurisdiction in which any specified court or other court is located, in which any suit, action, or proceeding may at any time be brought solely for the purpose of enforcing or executing any related judgment, to any immunity from suit from the jurisdiction of such court. And then I move down to the sixth last line. The Republic has hereby irrevocably agreed not to claim and has irrevocably waived such immunity to the fullest extent permitted by the laws of such jurisdiction. That's just above E in the lettering. I won't go through all of the judgments in NML, but the court will recall that Lord Phillips and Lord Collins, just to give the references at page 586 and 610 of the supplementary bundle, of the main bundle, held that this was an express waiver for the purposes of Section 2 of the State Immunity Act. Lord Phillips added that, were it otherwise, that would deprive the clause of all effect. Now, it is clear that Lord Collins regarded the first paragraph as sufficient to constitute the waiver, but both Lord Phillips and Collins referred to the second paragraph in reaching their conclusions. But this language in the bond is materially different to what is in Article 54.1. In Article 54.1, contracting states have accepted an obligation to extend the jurisdiction of their courts to allow for recognition and enforcement of ICSID awards. In NML, Argentina alone has consented to the enforcement of a judgment in any court. And it has done so while stating that it irrevocably waives any immunity from suit from the jurisdiction of the court. That is not Argentina taking on an obligation to extend jurisdiction within its own courts, but rather it is a waiver of its immunity in other courts. That is the language which is not found in Article 54.1. This language is in line with the distinction between states agreeing to extend the jurisdiction of their courts and states waiving immunity before other courts. The two are different concepts. One does not imply the other. Now, in my submission, my lords, my lady, NML does real damage to the basis on which the respondents wish to say that Article 54.1 is a submission to jurisdiction. It defeats the consented to argument. And that is because Article 54.1, in its language, is actually much closer to what was agreed in Article 5.2 of the Torture Convention. I won't take you back there, but the court will recall that Article 5.2 required each state party to take such measures as may be necessary to establish its jurisdiction over the relevant offence. There, the states parties had accepted the obligation to extend the jurisdiction of their courts so as to allow for the prosecution of torture. That's not a waiver at all. That is the nature of the obligation that we see in Article 54.1 as well. Not a waiver, but an obligation to extend the jurisdiction of one's courts. Quite different to the language and the nature of the obligation undertaken by Argentina in NML. If there is to be a spectrum between the provision in NML and the provision in the Torture Convention, in my submission, Article 54.1 is much closer to the latter end of that spectrum, to what is in Article 5.2 of the Torture Convention. By resting ultimately on NML, as the respondents do, at least in the Zimbabwe appeal, that with respect highlights how different the nature of the obligation is in NML compared to Article 54.1, and highlights that there simply is no waiver in that latter provision. The only thing Spain is obliged to do, and that other contracting states likewise, is enact the equivalent of the 1966 Act within its territories. My lords, my lady, I've taken time on the text and the nature of the obligation, because in my respectful submission, that is going to be the core of the determination of Ground A. But I do wish to take the court through some of the object and purpose points and supplementary means of interpretation points. But I'll seek to move reasonably quickly. The first, as I've said, is it's not disputed between the parties that the principal purpose of Article 54 was to ensure that a domestic mechanism existed for the recognition and enforcement of awards against investors. I had my exchange with my Lord Legate about the way in which we rely on this, and I don't put it any higher than that it is a supplementary means that confirms Spain's interpretation. I will take the court to one instance where in the Travaux this principal purpose was identified, but there are numerous times where it is so. Could we please look at the Travaux préparatoire from the Santiago meeting, which is at bundle tab 219, page 3215. So at page 3215, at the very top, we see an instance of where this principal purpose of Article 54.1 is articulated. It was referred to in the drafting as Section 15. The chairman, which is Mr. Aaron Broquez, he was the chairman of the negotiations and the general counsel of the World Bank, is recorded as saying this: he saw no particular reason for differentiating between the two cases, which are dealt with by Lowenfeld, the US delegate on the previous page, and in fact had deliberately placed them on the same level. As he had indicated in his opening statement, the principal purpose of Section 15, although this was not its only effect, was to give states which had been successful plaintiffs a means to enforce awards against investors who did not have assets within the host state's territories. States would be directly bound by the Convention to comply with awards rendered against them which could not be void of investors. In the unlikely event that a losing state failed to comply with an award, it would be in clear violation of the Convention itself, and the state whose national had failed to obtain satisfaction could take up his case. That last sentence, my lady, goes to the discussion we had about what would happen. So I'm grateful for that indication earlier. Now, this is populated as a point throughout the Travaux préparatoire. We accept, as I indicated to my Lord Legate, that Article 54.1 does not have as its only purpose the protection of contracting states that succeed in an arbitration against investors. But throughout the Travaux préparatoire, this point is made time and again, and at no stage is there an indication that Article 54.1 is a submission to the jurisdiction by one contracting state to the jurisdiction of all other contracting states. Put bluntly, state award debtors were not in the mind of the drafters of Section 15, which went on to become Article 54.1. I won't take the court to all other transcript references, but I will, for the transcript, just indicate where they can be found.
But I mean, it's a step up from saying it's not a primary purpose to saying the consequence is not even in their mind, particularly if one looks at this paragraph, where the Speaker, the Chairman, clearly does have it in his mind, even though he thinks it's unlikely.
Well, my Lord, with respect, I would not suggest that the Travaux here is so clear as to say that the Chairman has in his mind that each contracting state is submitting to the jurisdiction of all other contracting states.
No, but he has in his mind the even-handedness, if you like, of a provision that on its face appears to work both ways.
I'm sorry, my Lord, I didn't...
He has in his mind the apparent even-handedness of a provision which appears to work both ways.
And that may well be so, but what that doesn't go to address is whether this would indicate that there is a waiver of immunity.
No, I take that, but I think you were going on to say that they just wouldn't even be sort of thinking about enforcing against states.
Oh, pardon me, what I was saying that where state award debtors was not in the mind of the drafters, that was in circumstances where the suggestion against me is that it was in the mind of the drafters to constitute a waiver of immunity. So the point which I'm taking, my Lord, is not simply that is not actually that a state could not be an award debtor, but rather that there is no suggestion, indeed no trace within the travaux, that there is a waiver of immunity by states when they sign the ICSID Convention.
And I understood actually your submission to go a little bit further than that, because looking at it being said, well, what happens if a losing state fails to pay? The remedy is said to be that the state whose national have failed to obtain satisfaction could take up his case. So that would suggest not a waiver case, in which case the investor could take it up, but
quite so, my
have
lord.
State-to-state enforcement.
Quite so, my lord, and that is the second point that I make about the travaux, which confirms that the waiver of immunity that my learned friend suggests exists in the provision was not reflected in the travaux. I'll just simply state that this same point can be seen at bundle page 3218, 3231, 3237.
Can you go a bit slower, sorry?
Pardon me. I'll repeat those. 3218, 3231, 3237, and 3259, all statements by the chairman.
So not equal or reciprocal treatment, but different treatment. States wouldn't be subject to the enforcement provisions. There'd be international court adjudication.
No, my lady, that's not the point.
That's
it wasn't
not
that there is a differential point between investors and states.
Oh.
It was that a waiver of jurisdictional immunity by states in the domestic courts of all other contracting states was nowhere indicated in the travaux. So even if the drafters had in mind that an award could be recognised and enforced against an investor or against a state, what they certainly didn't have in mind was that the creation of a jurisdiction by each contracting state to achieve that subject matter would implicitly require a waiver of adjudicative immunity by each contracting state.
But that could only be because there was this different remedy.
The different remedy in Article 2764. Yes, that is one point.
So it wasn't an equal approach to investors and states.
Well, certainly there are other options that can be used against a state, which is Articles 27 and 64.
Yeah. Well, that, you said, was the mechanism.
That is a mechanism, yes. But the reason I'm being quite careful with language here, my lady, is that I also don't want to cut across paragraph 57 of arrest warrant. There, the International Court of Justice made clear that even if the subject matter of a treaty extends or requires a contracting state to extend its jurisdiction, that is a different concept and a different matter to a waiver of jurisdictional immunities. So the answer to your question is yes, Articles 27 and 64 do create additional or different mechanisms.
Well, it's the, I mean, 54 isn't the mechanism if immunity is preserved.
Well, with respect, my lady, no, that's not right. Oh. And the reason for that is that immunity can be preserved, but then if an exception to that immunity is proven, in the way that we reviewed Hansard and the Solicitor General said that yes, it can, okay, then there is a route through that immunity.
But that's the only way is Section 9 then?
Correct, my lady. And that's what we'll be discussing on Wednesday and Thursday. What it is not, as the Solicitor General in his statements made entirely clear in my submission, is a route via Section 2 of the State Immunity Act, because there simply is not a submission to jurisdiction in Article 54.1, and there is no trace of it in the travaux préparatoire. And just so I can be crystal clear on the point, when I say there is no trace of it, I mean there is no trace of those negotiating the convention thinking that Article 54.1 contained a waiver of that immunity, i.e., that every state that signed the convention was submitting to the jurisdiction of every other contracting state. My learned friend Mr. Moulin will develop these points more, I understand, so I'll move beyond the travaux now and just deal with the point briefly that I've been trailing in my language so far, which is that these travaux contain no trace of the drafters intending Article 54.1 to be a submission by one contracting state to the jurisdiction of all others. And if we can please pull up Lord Gough's speech in Pinochet, that's at tab 58, page 802. One can see there at 219E, His Lordship picks up in the third line, nothing in the negotiating history of the Torture Convention, there is nothing that, in the negotiating history of the Torture Convention which throws any light on the proposed implied term. Certainly the travaux preparatoires shown to your Lordships reveal no trace of any consideration being given to waiver of state immunity. His Lordship goes on to make a similar point at paragraph 221, at page 221D. It's quite a significant point in my submission, drawing on what Lord Gough has said, that there is the absence of any trace of a submission to jurisdiction, i.e. a waiver of immunity, in the travaux of the ICSID Convention. If the drafters had understood Article 54.1 to be a submission by each contracting state to each other contracting state's jurisdiction, that would have been discussed at some point. So too is the absence of any such indication in the United Kingdom's process of ratification of the 1966 Act, and then again when it was revisited in the drafting of the 1978 Act. The fact that there is no such trace confirms that there is no such submission. The second point that I wish to make around supplementary means is a point of international law. I know I do not need to labour the point that international law, and indeed English law, regards state immunity as a matter of the greatest importance, to quote Lord Justice Collins as he then was in ETI and Bolivia, which is at page 364 of the bundle. With respect, that is undoubtedly correct, and being so, one ought to treat an implied dispensation of state immunity with caution. Now please take the court to the decision of the Chamber of the International Court of Justice in Elsie. This is behind tab 79 at page 1090 of the bundle.
1090?
1090, yes,
yeah.
my lord. And picking it up at paragraph 50 in the middle of the page, the court there notes, the United States questioned whether the rule of the exhaustion of local remedies could apply at all to a case brought under Article 26 of the FCN Treaty. That article, it was pointed out, is categorical in its terms and unqualified by any reference to the local remedies rule. If we can just read down to the last three sentences beginning the middle of the paragraph. The Chamber has no doubt that the parties to a treaty can therein either agree that the local remedies rule shall not apply to claims based on alleged breaches of that treaty, or confirm that it shall apply. Yet the Chamber finds itself unable to accept that an important principle of customary international law should be held to have been tacitly dispensed with, in the absence of any words making clear an intention to do so.
So this is talking about the implied rejection of the exhaustion of local remedies rule in relation to the presentation of an international claim.
Yes, my lord, exactly. And in the same way that the Chamber of the Court there was expressing real caution about reaching a finding that there had been a tacit dispensation with that important rule of customary international law in that case, so too in my respectful submission, ought this court exercise real caution in saying there has been a tacit dispensation of the important principle of international law, there is state immunity, in Article 54.1 of the ICSID Convention. Indeed, this reasoning at paragraph 50 by the Chamber applies analogously here. When interpreting the ICSID Convention, one should not find it has tacitly dispensed with that important rule of customary international law without words showing a clear intention to do so. The text of 54.1 does not dispense with that important rule. There is no trace in the travaux that that important rule is dispensed with. and applying this finding of the Chamber in Elsie, there is no basis to say that there is a clear intention to do so. Third point on supplementary means is that in any event, the ICSID Convention is the wrong place to look for a submission to jurisdiction. Now, Professor Schroyer is a leading commentator on the ICSID Convention, and he published a book following his Lauterpacht lectures given at Cambridge. That's located at tab 203, page 3033, so 3033. Starting halfway down that page, my lords, my lady will see that Professor Schroyer says, therefore, the ICSID Convention on its own would not be a valid ground for withdrawing immunity in proceedings to enforce an award. Then he continues, importantly, but a combination of accepting submission to arbitration as a waiver of immunity and of the ICSID Convention as providing the necessary jurisdictional link to the forum state may achieve this result. If, by virtue of a statutory provision containing an arbitration exception to immunity, or a waiver clause accepting submission to arbitration as an implicit waiver, immunity is denied in principle in the respective country, then the general obligation contained in the ICSID Convention to enforce awards should overcome any lack of a jurisdictional link to the forum state. It's quite clear that Professor Schroyer's position is that something more than the Convention is needed. Article 54 is, of course, predicated on there being an award. That award arises out of an arbitration agreement. It is that arbitration agreement, if valid, that can waive adjudicative immunity. Just as my exchange with my lady, Lady Simler, a few minutes ago indicated, the route through is the arbitration agreement. Section 9 under our Act, not reading in and squinting at the words in Article 54.1 to say, I think I might be able to make out an implicit submission to jurisdiction in the shadows. As Professor Schroyer says, one is simply looking in the wrong place if one seeks to derive a waiver of immunity from Article 54.1. Just while I'm on this page, I will say that my learned friends do seek to emphasise the sentences just before where I picked up on the quote. These are the sentences saying the Convention provides that each contracting state shall recognise and enforce an ICSID award as if it was a final domestic judgment, footnote to Article 54.1. However, it also reserves the validity of state immunity rules in the contracting state, footnote to Article 55. My learned friends suggest that this means Schroyer says only execution immunity is reserved in the law of contracting states because only Article 55 appears in the footnote. Of course, I'll wait to hear what my learned friends say, but with respect, there is no force in this argument. It can't be reconciled with the rest of the text that we have just looked at, where Professor Schroyer is clear that one needs a valid arbitration agreement or a waiver in addition to what is in the ICSID Convention if one is to dispose of adjudicative immunity. This passage, I respectfully submit, is quite damaging to the respondent's case in relation to what is contained in Article 54.1. There is one other reference that my learned friends for the respondents refer to. I'll just deal with it here. Schroyer has also authored a commentary on the ICSID Convention. Those who have seen it before remember it's quite a thick now set of 2 volumes. His comment in the commentary on Article 54.1 repeats what we saw earlier. I won't go to it, but it's at page 3586 of the bundle, where he says, submission to arbitration may be seen as a waiver of immunity in proceedings to have the award recognised. That is the consistent position of Professor Schroyer himself, from the Lauterpacht lectures through his commentary in Article 54.1 in the larger volumes of commentary. But my learned friends say that one should actually then turn to the commentary in Article 55, and that is located at page 3619 of the bundle. And one can see in paragraph 7, the language is recorded, recognition is governed by Article 54. The obligation to recognise an award as binding under 54.1 is unconditional. Under Article 54.3, only execution, but not recognition, is governed by the law of the foreign state. Article 55, by its own terms, refers to execution, not recognition. Therefore, state immunity cannot be used to thwart proceedings for the recognition of an award. And the footnote there is to the first instance judgment in the ICSID proceedings in Australia.
I'm sorry, I've picked up a wrong page number. Can you give it to me again?
I apologise, my Lord. It's bundle page 3619.
Ah, thank you.
And that quote that I just read, with respect, is not of assistance to the respondents. It does not say that Articles 55, or indeed 54, are a waiver. Rather, it suggests that some other mechanism, and it doesn't say what that mechanism might be, needs to be available to provide a route through adjudicative immunity. That is, the foreign state must not allow immunity to stand in the way of recognition, which, as I explained earlier by diverting to Hansard, is what the UK has done through Section 9 of the 1978 Act, not Section 2. Now, my learned friends wish to read this passage differently, but not consistent with the position that Professor Schroer has articulated over years in the Lauterpact lectures and in multiple volumes of his commentary. And so if one turns over the page, also to page 3620 in the bundle, one sees in paragraph 11, about 2/3 of the way down, that a passage from Particular in Romania, the decision of this court, is referred to. And it's quoted there in emphasising that the ICSID Convention makes no attempt to harmonise the law on state immunity among the various states. This is consistent with what I have said throughout these submissions. The mechanism to provide a route through adjudicative immunity is left to the contracting states. And here the UK has done that. It has done that expressly in the terms of the Solicitor General through Section 9 of the 1978 Act. In my respectful submission, care should be taken with my learned friend's arguments on the Schroer commentary. And that's especially so given this chapter 55 was not updated by Professor Schroer himself, whose consistent views are those that I have put to the court in the Lauterpact lectures and indeed in the commentary to Article 54. My lords, my lady, I see that I'm at my time. With the court's indulgence, I might borrow 10 minutes from the time allocated to me in reply at the end of tomorrow, just to complete my submissions in opening.
Yes, very well.
I'm grateful, my lord.
Can I just check? Footnote 14 on page 3620 refers to a work by Schroer on state immunity. Was that the first of the references you gave us?
Yes, my lord.
Yes,
okay. My lords, my lady, the last point from object and purpose and supplementary means was English materials at the time of the ICSID Convention and shortly after. I've shown the court already Hansard for the 1978 Act. I will not take the court to Hansard for the 1966 Act, but the relevant page is page 3151 in the bundle. And in that Hansard, there is no suggestion that the ICSID Convention meant that all contracting states to it would be submitting to the jurisdiction of English courts, or indeed that the UK was submitting to the jurisdiction of all other contracting states' courts. And that's quite important for the point that my Lord Lloyd-Jones made earlier this morning. One must recall that at the time of the 1966 Act, the law was that a foreign state had to plead a submission to the jurisdiction in the face of the court. The authority is Kayhan and the Pakistan Federation, which one can see at page 431 of the bundle. And the
which is now explained in an ML as having been wrongly decided.
As being, well, there is a observation in NML that Kayhan may well have been wrongly decided.
Well, as Lord Collins explains why it was.
But the point is that at the time of the 1966 Act and its incorporation into English law, that was the law of the land. So even if, with the benefit of decades later, it is said that may well have been wrongly decided.
Your point is it was understood to be the law at the time.
Exactly so,
yes.
my Lord.
Yes.
And the reason that understanding is important is that if it were the case that a foreign state could submit to the jurisdiction of English courts by a treaty, i.e. not in the face of the court, that would have been understood to be a major change to the rule that was otherwise understood to apply from Kayhan and Pakistan. The ICSID Convention and the 1966 Act would have brought about quite a sea change to that understanding at the time. It surely would have been noted either in Hansard or in the leading texts as they stood at the time. And you'll have seen that we have quoted the text of Darcy and Morris and Hallsbury's from the relevant editions immediately post-dating the 1966 Act at paragraph 48 of our written case. My lords, my lady, I come now to the foreign judgments. I will take this quite briefly, as my learned friend Mr. Moulin will be engaging with some of these in more detail. The point that I wish the court to take away in the time I have remaining is that this key textual point that I've spent most of my time on about the interpretation of Article 54.1 has received little focus in prior decisions. One decision that did focus, even if concisely, on the language of Article 54 was that of Mr. Justice Walbank of the Eastern Caribbean Supreme Court in Tethian and Pakistan. If the court can just go to page 2087 of the bundle, behind tab 144, one sees Mr. Justice Walbank's decision. The relevant paragraph is paragraph 51.
51?
51 on page 2092 of the bundle. And if we actually pick it up at 50, we see that Mr. Justice Walbank said that TCC, the enforcing investor, advanced a new case at the substantive return date that there was a submission by agreement in the ICSID Convention itself. That is said to be clear from all the textbooks and the case law. Having been in that room, it was not actually cited what those textbooks and case law were. However, at 51, Mr. Justice Walbank continues, Article 54.1, at paragraph 51, he continues, Article 54.1 of the Convention imposes on Pakistan an obligation to allow recognition and enforcement of the award before its own courts. Article 54.1 places no obligation of Pakistan at all before the BVI courts, and so it cannot constitute a waiver by Pakistan of its immunity or anything else. Concise, but dealing squarely with the textual point, reads the terms of 54.1 and appreciates the nature of the obligation, i.e. what I have called a Scenario 1 obligation. By contrast, this textual point received very little attention below in this jurisdiction. Mr. Justice Fraser did not deal with it at all at first instance. The Court of Appeal dealt with it indirectly and very briefly. I won't take the court to it now, but the relevant page is in Spain's key documents at page 164. And at paragraph 79, the closest the Court of Appeal gets to the analysis of within its territories and in that state is when it says, it is also clear as a matter of language that a contracting state does not merely agree by Article 54 that it will recognise and enforce awards in its own jurisdiction, but also that awards to which it is party will be recognised and enforced in other contracting states as though a final judgment. Then there is a citation to this court's decision in Mikula, paragraph 105. With respect, that simply does not engage with the textual point. Unlike Mr. Justice Walbank, it does not analyse the text of that provision or consider the nature of the obligation it imposes. And perhaps quite remarkably, the reference to this court's decision in Mikula at paragraph 105 is quite off the point. In Mikula, that
which paragraph? 105, you say?
Yes. How many, Mother?
105, did you say?
That is the paragraph from Mikula that the Court of Appeal quotes in paragraph 79 below.
Thank you. Yes.
And paragraph 79, I think your Lordship has it. But what this court said in Mikula at paragraph 105 is simply that the UK owes the obligation in 54.1 to all other contracting states. Quite so. That's exactly the same as what we saw in the Torture Convention.
But, I mean, that's because the court in Mikula had to focus on that to deal with the EU law arguments that were being presented against. So that was the only really important feature of the ICSID Convention that we needed to deal with.
Quite so, my Lord. And indeed, what was not dealt with in Mikula was anything to do with state immunity. So it is very difficult, with respect, to see how the Court of Appeal below, in its very cursory comments on the text of Article 54.1, says that Mikula helps it find a submission to jurisdiction and a waiver of state immunity in Article 54.1. It doesn't. It just simply doesn't.
Right, but what about paragraph 104, though? This is page 548. I mean, that talks about the convention scheme being one of mutual trust and confidence involving effective recognition and enforcement of awards. Might it not be said that that's the more relevant part of Mikula?
Sorry, my Lord, I didn't have
sorry,
the reference on my page.
It's page 548.
Yes.
You were citing 105, and we've just debated that. And I was just pointing out paragraph 104 is the court talking in more general terms about what the ICSID Convention is about.
Indeed, in more general terms, but again, in circumstances where there is no reference to state immunity or whether there is a waiver of state immunity in Article 54.1 in satisfaction of Section 2. Indeed, in my respectful submission, but in all deference, of course, paragraphs 104 and 105 are simply saying that each contracting state owes the obligations in Article 54, and indeed the ICSID Convention generally, to the other contracting states to the Convention. That does not take the matter forward at all. That is acknowledged and not disputed in each of my Scenario 1 and Scenario 2. Therefore, what is said in Mikula 104 and 105 is a non-disputed part of both the appellant's and the respondent's case. What is disputed is whether Article 54.1 goes further to constitute a waiver of immunity. My Lords, my Lady, I see that I'm at time. If I would just conclude briefly. My learned friend Mr Moulin will deal with the decision of the High Court of Australia that the court has no doubt focused on. Again, Spain's core position is that there is no close textual analysis of Article 54.1, and in particular the language of within its territories and a court in that state. No consideration of the nature of the obligation by the High Court of Australia. In relation to my learned friend Mr Green's issues number 3 and 4, I understand from a helpful indication just before court sat that some parts of this are no longer advanced, so I'll wait to hear what Mr Green says over the course of tomorrow and reply to the extent necessary. My Lords, my Lady, unless there is anything further.
Thank you, Mr Bastian. So out of your 30 minutes of reply time, you've used up 10.
I'm grateful, my Lord.
30 left. Thank you.
May I inquire if the court would like a break while we change, or should we just persist?
We just carry on. Thank you very much. Mr. Muller.
We have prepared a one-page document setting out the structure of our argument. I've discussed this with my learned friends. It contains no submissions. It's literally just a map of the argument. That has been emailed to the registry, but I was wondering whether you might want hard copies so you can follow the argument.
Yes, if it saves time. Thank you very much. you. Thank you.
My lords, my lady, as you will see, there are 6 proposed sections. Where we get to is a different matter. But the last 3 sections on Hansard, the New York Convention waiver point, and tiny prejudice points by border are not terribly important. So I will have 4 introductory points, which I will cover in a minute, but the focus of the submissions obviously will be on Part B, the interpretation of Article 54.1. And let me foreshadow now that the main focus of the submission will be to answer the question of my Lord Lloyd Jones as to what the proper test under public international law and under Section 2 of the State Immunity Act is for a waiver of state immunity. Does it need to be express? What do we mean by express? So that will be the whole, or a large part of what is Part B2 will address that by reference to Pinochet and the Court of Appeal's decision in Lama. Starting with my first introductory point, we say there are 3 levels of implication at play in the interpretation contended for by the respondents. That Article 54.1 operates as a waiver of immunity from adjudication under public international law and a submission to the jurisdiction under Section 2 of the State Immunity Act. First, the point on mutuality, covered by my learned friend, Mr. Bastin, in which we respectfully adopt. Now, our argument proceeds on the basis that you are against us on this, on that first layer, mutuality, one could say paragraph 105 of Mikula. We adopt Spain's submissions, but we move on to the second and third levels of implication. And that second level of implication is that we say it does not follow from the fact that a state agrees to another state enforcing an award rendered against it, as in this case, or prosecuting one of its officials, as in Pinochet, that that state thereby agrees to waive state immunity. That second implication, which we say is impermissible applying Pinochet, which itself, and that is important, of course, to understand, applied public international law, will be the main focus of my submissions. And there is a third level of implication which we would respectfully characterize as completely misconceived, which consists in deducting from the fact that the contracting states to the ICSID Convention have stated in Article 55 that nothing in Article 54 shall be construed as derogating from the law in force in any contracting state relating to immunity of that state, of any foreign state, or of any foreign state from execution, that it must follow that they agreed to derogate from their immunity from adjudication. To deduct rather, from the absence of apples, the presence of oranges. Article 55, which everyone agrees was introduced purely for the avoidance of doubt, says nothing one way or the other about waiver of state immunity from adjudication. If such a waiver is to be found, it must be found in the terms of Article 54.1 itself. And, my lords, I will cover that point by reference to when we come to the High Court of Australia's judgment, because they put particular weight on Article 55, so I'm going to deal with it there. If you'd rather I dealt with it at any earlier stage, because it's on your minds, very happy to do it. And if we are running out of time, I will absolutely cover it. Now, our second introductory point is that there should be no substitute for analysis. And we say that because in the court below, regrettably, the respondents, both respondents, have invited the court to shirk analysis on the basis that the issue had effectively already been decided. Now, thankfully, this sort of point disappears as one goes further up. But it does still linger, and this is why I address it up front. Before Mr. Justice Fraser, ISL submitted, in effect, that Mikula had already decided the question, and that we say, with all due respect, did lead Mr. Justice Fraser astray. That contention was not pursued before the Court of Appeal, and rightly so. Mikula, of course, does not decide the point at issue in the present appeal. It does not consider, let alone decide, the question of state immunity. It is relevant, of course, and that is something I will address, but it does not allow one to avoid analysis. Similarly, the way in which the case was argued in the Court of Appeal led to the Court of Appeal to place, we say, undue and overly great reliance on the High Court of Australia's judgment. And that is the way in which the invitation to avoid analysis still lingers. The submission that applying Islam, this court should be slow to depart from the decisions of, in particular, the High Court of Australia. And we say that is wrong at two levels. First, because the issue being considered in each of these foreign courts was different. And it was whether Article 54.1 constituted a waiver of immunity applying their own domestic regimes of state immunity, which differ widely from ours. The United States allows implied waivers of immunity, expressly by statute. Australia's arbitration exception, which is in Section 17 of its Foreign State Immunity Act, does not apply at all. So that unless the High Court of Australia had found that Article 54.1 constituted a waiver, applying its own, with respect, peculiar developments on Pinochet, no ICSID award could ever have been enforced in Australia against the state. So it's important to understand that they do not have the equivalent of Section 9. Now, the respondents say that does not matter because the court was interpreting Article 54, as your lordships and your ladyship have to do. But the reality is that it did weigh directly on the High Court of Australia's decision. It was inevitable that it would. And one can see that, first, from the way in which they develop, which they are absolutely entitled to do, Pinochet in Australia, and secondly, from the part on interpretation itself of Article 54.1, where they use a contrario argument to say, well, it can't be that, therefore it must be that. And that is, we will show you that when we get to the judgment. So that's the US, that's Australia. In France, and that is very important to realize, the absence of adjudicative immunity from the process of enforcement, the so-called exequatur, arises from the existence of an arbitration agreement with no review whatsoever, whether de novo or otherwise, of arbitral jurisdiction. That rule, which already existed, and we've done some historical digging, that rule which already existed at the time of the negotiation of the ICSID Convention applies to all types of arbitration, not simply to ICSID arbitration. So again, the analysis is that which Professor Schroyer explains. You look at the arbitration agreement. Now, in France, they decide not to review it at all. They say there's an award, we're not going to look at jurisdiction again. That's their right. We do in this jurisdiction. Now, New Zealand is even better. It has no state immunity legislation at all. And we do say the one jurisdiction where the issue has been decided and which has the exact same legislative framework as this jurisdiction is the BVI, where Mr. Justice Wallbank has held that there was no waiver. And I was paused to note, given the implied criticism that is made of Mr. Justice Wallbank, that he is a very experienced judge who has been positively reviewed at the highest level in the Privy Council. And I'm referring to, it's not in the bundles, but this is just, by the way, Livingston against Eurochem, 2020 UKPC 31, where Lady Arden referred to Mr. Justice Wallbank's impressive judgment. Now, that's the first level at which the invitation to apply Islam is wrong. The second level at which the respondents' reliance on Islam is wrong is that the principle in favor of uniform interpretation only requires deference to foreign judgments when there is a consensus between those judgments. And there is no such consensus. The BVI, of course, is at odds with the respondent's position. In the US, the only, and again, it's important to understand this with respect, my lords, my lady. The only exception that existed until 1988 was the implied waiver exception. The arbitration exception, the equivalent of our Section 9, though wider, was only introduced in 1988. And I'll just give you the bundle references. For the implied waiver exception, page 2270 of the authorities bundle, and for the then new arbitration exception, page 2274. And since then, the US courts have been progressively shying away from the implied waiver exception for the enforcement of ICSID awards and are relying instead on the arbitration exception. And as I will show you, we can see that from a brief which they filed last year in the Court of Appeal for the District of for Washington, D.C., the position of the US government itself is that Article 54.1 does not constitute a waiver. So that's the US position, BVI US. France, as I have explained, does not reason by way of waiver. The rule there is that the question of immunity from adjudication does not apply to an executor for any arbitral award. The reasoning is not waiver. So the rule in Islam is accordingly no basis, we respectfully submit, to shirk analysis of the respondent's contention that Article 54.1 of the ICSID Convention operates as a waiver of immunity from adjudication under public international law and as a submission to the jurisdiction under Section 2 of the SIA. Now, before leaving this point, my lords, my lady, I would like to address a latent assumption contained in the respondent's submissions on the foreign judgments. And that is that the judgment of the BVI court should be accorded no or very little weight, whereas that of the High Court of Australia should be accorded great weight. And we respectfully submit that that assumption is unfounded. With all due respect, Australia is not a prominent arbitral jurisdiction. Their arbitration centre, ACICA, had 13 new arbitrations commenced last year, 13. The equivalent number for the LCIA here in London was 318, and for the LMAA, 1,733. And this is without counting more specialized institutions such as GAFTA. This court's judgment, therefore, will be the first time that a heavyweight common law arbitral jurisdiction, the other two being Singapore and Hong Kong, that are both watching very closely, will be considering this point. So that concludes my second introductory point. We need to grapple with this. We need to understand what Pinochet decided. We need to know what express means. We need to see how to apply arrest warrants in this jurisdiction. Now, my third point is about the scheme of the ICSID Convention, and it relates to this so-called internalization of the grounds of review. And that is internalization, of the grounds of review when compared in particular to New York Convention awards. To remind your lordships and your leadership, for New York Convention awards, recognition and enforcement of an award may be refused when one of the grounds contained in Article 5 of the New York Convention is satisfied. Now, this will include failures of due process, lack of capacity, lack of jurisdiction. For ICSID awards, those grounds have been internalized and given to a second-tier arbitral tribunal, which is termed an ad hoc annulment committee, and that arises under Article 52. Now, it's important...
Sorry, Article
52.
52.
52 of the ICSID Convention. Now, it is important, my lords, my lady, to understand what this does and does not mean. It means that it is not open to a respondent to an enforcement action to challenge enforcement of an ICSID award in the way in which a respondent can challenge enforcement of a New York Convention award. The grounds of review have been internalized. They do not arise again before the enforcing court as grounds of review. But, my lords, my lady, that says nothing about state immunity. State immunity is not a ground of review. It is a principle of public international law given statutory effect in this jurisdiction by Section 1.1 of the State Immunity Act. To the extent that, as Zimbabwe contends, the correct route through the SIA is Section 9, my lady, of the State Immunity Act, this entails a de novo consideration of the existence of an arbitration agreement, not as a ground of review of the award, but because that is what Section 9 requires. And if you could look, please, at Tatneft to make good that submission, this is in the Authorities Bundle, tab 51, page, the authority starts at 618, but I'm looking at page 626.
I didn't quite catch the name of the case.
Tatneft.
Thank you. And I'm sorry, the page number there.
Of course. Page 626.
Thank you.
Yeah. And you see what the judge there says at paragraph 35, where the submission had been that Ukraine could not deploy new arguments on jurisdiction. I consider that Ukraine is correct to say that it is not precluded by what occurred before the tribunal from raising the points which it has at this hearing. By reason of section 1.1 of the SIA, it is immune from the jurisdiction. It is immune from the jurisdiction of the court unless an exception provided for in the SIA applies, and indeed the court is obliged to give effect to that immunity even if the state does not appear. What that entails in the present case is that the court would have to give effect to the immunity unless it is satisfied that the state has agreed in writing to submit a dispute to arbitration and the proceedings relate to the arbitration. If there is an issue which is either apparent to the court of its own motion or is raised by the state and which goes to the question of whether there was such an agreement in writing in relation to the relevant dispute, then I consider that the court is obliged to consider it and can only exercise jurisdiction over the state if satisfied that the Section 9 exception is nevertheless applicable. There is nothing in the SIA which suggests that there can be a foreclosure of the points which the state may raise as to the applicability of the immunity by reason of what may have occurred in front of an arbitral tribunal in a way similar to that provided for by the Arbitration Act, and he notes in particular there is no equivalent to Section 73. And that was said, my lords, my lady, in the context of a New York Convention award. But the analysis, of course, is exactly the same, whether you are faced with an ICSID award or a New York Convention award.
And I'm so sorry, Section 73 of the Arbitration Act?
It's about waiver law.
Right, okay.
Yes. 1996 Act, you know. 1996, the Arbitration Act, 1996.
So Tatneft was concerned with a New York Convention award.
My lord?
This case, Tatneft was
Tatneft is concerned with the New York Convention award. Yes. But the point I'm making is that it so happens that there is an overlap between what the State Immunity Act requires the court to do and what you do under the New York Convention on jurisdiction, right? The New York Convention allows you to review as a ground of review for lack of jurisdiction. But what the judge is explaining here, which is not being disputed, I understand, in this appeal, is that under Section 9, the terms of Section 9 themselves, which are applicable because of Section 1.1 of the State Immunity Act, require the court to decide the question of jurisdiction. And the point I'm making is that that is entirely separate from whatever grounds of review you may or may not have against the award. That arises out of the law of state immunity and out of the principle which has force of law in this country laid down by Section 1.1 of the State Immunity Act. Which is what?
I think this is a point for days 3 and 4, is it?
It is, and it isn't, my lord, because we'll see how the argument develops. But the argument has been that because the scheme of the New York Convention is such that the grounds of review have been internalized, the ICSID Convention, of the ICSID Convention also that they have been internalized, then it must follow that nothing can happen anew before the domestic courts. That's how it was put in the Court of Appeal, and that's why I'm dealing with it. We will see how it's dealt with. I did not want you, when hearing my learned friend's submissions, to have any doubt in your mind as to how separate these two issues are. What you were considering, for example, in Mikula, when you're describing the scheme of the ICSID Convention, all correct with respect, but it says nothing at all about state immunity. Which
so your point is that under both the New York Convention and under ICSID, the review procedures are internalized to a certain extent, and in neither case does that extend to state immunity. The internalization of review procedures in neither case, New York Convention or ICSID, extends to state immunity.
It does not.
Yes.
It makes no difference that the grounds of review have been internalized. What they have done is take what was in Article 5 of the New York Convention and put it in Article 52 of the ICSID Convention. And we know that also when we'll go to the travel, I'll show that to you as well, because this internalization of the grounds of review is expressly discussed, and the chairman, Mr. Brockes, explains time and again that the difference is understood as one of degree and not of kind. And we've given you one quotation for this, which is at paragraph 42 of our written case, which is call, page 84. And to conclude on this point, my lord, my lady, about how it doesn't matter that you're faced with a closed code when interpreting Article 54, I would just draw your attention to the fact that this court has also held in a case which, like Mikula, was concerned with the availability of a stay outside the scheme of the Convention, that the New York Convention also constitutes a closed code. And that was the decision in IPCO against NNPC. If you could please look at page 431 of the authorities bundle. The question, as I say, was whether the court could grant a stay outside the terms of Article 6 of the New York Convention. So very similar to what you had to decide in Mikula. And Lord Mance delivered the judgment. If you start at paragraph 15 and 16 at page 439, and I won't read it, my lords, my lady, you will just see the issue explained. And then his decision is at paragraph 41 at 446. 446, where Lord Mance says, in my opinion, the conditions for recognition and enforcement set out in Articles 5 and 6 of the Convention do constitute a code. So in the same way that this court has found in Mikula that there is a scheme to the New York Convention, that with the internalization of the grounds of review, we have the same in the New York Convention, and that says nothing again about state immunity. My fourth point and last point in introduction, my lords, my lady, is that there is no disconnect between the question of interpretation of Article 54.1 and that of a submission under Section 2 of the State Immunity Act. And this deals with Border's submission that, on our case, there could be situations where there is a waiver but no submission. And the reference for this is paragraph 139.2 of Border's written case, which is call, page 162. With respect, we do not understand that submission. Our case, my lords, my lady, is that the House of Lords requirement in Pinochet that a waiver and a submission to the jurisdiction be express. And if I may insist, express, not expressed. There seems to have been a gloss put on that by my learned friends at times. That a submission to the jurisdiction be express is a requirement which applies at both levels. Their lordships in Pinochet were applying Section 2 so as to conform with public international law as they had to. So there can be no question of a waiver under Article 54.1 not being a submission under Section 2, right? But, my lords, my lady, and that is very important, the converse is also true. What Border cannot do, but which, as I will show you in a moment, they do try and do, is to run away from the test in Pinochet on the basis that this court can approach the question of interpretation of Article 54.1 free of the shackles of Pinochet. So forget Pinochet when you're interpreting Article 54.1. And then it would seem you simply waive it through Section 2. And I will show that to you in a moment by reference to their submissions. The rule that a waiver of state immunity must be expressed is, as held by the House of Lords in Pinochet, as much a rule of public international law as it is under Section 2. And we respectfully submit that should be obvious. But if you need authority to see it Well, we can look at the Vienna Convention on the law of treaties. And you go, please, to the supplementary bundle, so the first supplementary, at page 267. And you see under the general rule of interpretation of Article 31.
Sorry,
I'm sorry, SB 266. First supplementary. Not the joint authorities bundle. The first supplementary.
Sorry, it's the first one, I'm sorry.
Page 266.
Thank you.
Well, if you look at paragraph 3 of Article 31, you can see that there shall, and that is the primary rule of interpretation, Article 31, we are not into Article 32, there shall be taken into account, together with the context, any relevant rules of international law applicable in the relations between the parties. So very obviously the law of state immunity. Now, if I can take you, please, to the submissions of my learned friend for border, which is in the core at page 127. The core bundle, page 127, and the paragraphs I would draw your attention to are 46.4.1 and 46.4.2. In circumstances where the parties to both appeals agree that a waiver must be expressed, and is accepted, both as a matter of...
I'm sorry, Mr. Mullen,
I'm sorry.
Behind.
Core bundle.
Core bundle.
Page 162. 127.
127.
Yes.
The core bundle.
Paragraph.
It's electronically, it's not the key bundle.
Oh, I see.
It's not the same as the hard copy bundle.
Yeah.
No.
Oh, I see. I'm sorry, my lord. I'm looking at paragraph 46.4.1.
It's another call.
46.4.
Yes.
Yeah.
Yes.
And what is this document? Can you just remind us?
No,
There are two core bundles, my lords.
but it's
Yeah, we've got a Spain core and a
Oh,
Zimbabwe.
it's not the Spain core. I'm so
Zimbabwe.
sorry. I'll be referring to the Zimbabwe.
It's even
Also,
not the
please
same.
forgive me.
It
It's
does
even not
not
the
the
same in
same.
the Zimbabwe
no.
Well, mine, it is electronically, I'm happy.
electronic numbering.
Which is why I'm using.
Your citation has got me there.
So we're going to page...
It should be page 127 of that bundle.
Yeah, it is.
That works for me.
Good.
Yeah,
Does everyone
electronically?
but not in the core. In the
127 of the core bundle,
isn't-
paragraph 46.4.
46.4.
Yeah.
We're getting confused.
Yes, yes.
Just so you know, we have key
I know.
bundles, and they're different from the core bundle.
Yes.
You're referring to the core
Yes,
bundle.
we could discuss whether the key is more important than the core or the other way around.
But sorry, I asked, what is this document?
So this is Borders submission, Borders written case.
Where? Oh, now?
Yes.
Oh, right. Right, sorry, yes.
In the core, not in the key.
Yes, yes.
Right.
Okay. I've gone round in a complete loop. Right, now I understand.
Right. I'm grateful. So, the point I was making is drawing your attention to paragraph 46.4.1, where Border, our respondent, submits that in circumstances where the parties to both appeals agree that a waiver must be expressed, and I ask you to note both as a matter of public international law and Section 2, and they say this: it is irrelevant to engage in hypothetical analysis about the test for applying a term into a treaty. Well, we say that's the whole point of this appeal. You need to know what test to apply. And they go on to say, the relevant question is, what do the express words in Article 54.1 properly interpreted mean? If the answer is that the contracting states have consented to waive their immunity, then that is what they have done. I pause to say, applying what test? There is no elevated threshold by which the waiver must be shown to be necessary or essential to the operation of the treaty or treaty provision, although if it does aid in making the obligations therein effective or is consistent with the ICSID Convention's object and purpose, then that is to be factored into the inquiry. And I ask you please to contrast this with what they say at paragraph 17, which you find in that same core bundle at page 116. Paragraph 17. And here, with respect, they are much less coy. Under English law, and as agreed by all parties to both appeals, a waiver of immunity for the purposes of Section 2 of the SIA must be express. Express does not mean that the provision must use explicit words such as waive or immunity. As confirmed by Mrs. Justice Dias and the Court of Appeal and accepted by Zimbabwe, a waiver will be expressed where the words used on their proper construction amount to or lead to, and I emphasize those words, inevitable consequence that there is a clear or unequivocal agreement to waive immunity and therefore submit to the jurisdiction. My lords, my lady, we respectfully submit that Border's attempt at paragraph 46.4.1 and 46.4.2 to avoid that test, and we will look at the test, and it is actually incompatibility, it is actually inevitability, it is actually, as my Lord Lloyd Jones put it, as the amicus in Pinochet, is it workable? You're talking of effet utile, as I will show you.
So you're agreeing with 17?
Of course, my lady. Save that we say the first bit is a gloss, and we rely on inevitable consequences. But what we're certainly agreeing with is that you must analyze and deduce the test. My Lord, I see you looking at the clock. I would need 5 minutes to finish that point. Would you rather I do so, or would you rather break?
We'll finish the point.
Thank you. I'm grateful. So, we say that it is absolutely key to understand, and you will have to decide, what the test is to distinguish between a permissible inference and an impermissible one. When interpreting Article 54.1, in order to ascertain whether it amounts to a waiver of state immunity from adjudication, one must apply that test both as a matter of international law and as a matter of domestic law under Section 2, which aligns in that respect with international law. This court is faced with a provision, Article 54.1, which contains no words of waiver or submission. Now, we do not say that this means that you can never have a waiver. But what we do say, and we say it's obvious, is that if there is to be a waiver and submission, that has to be deducted through a process of inference. I'm using a neutral term, inference. The whole question on this appeal is whether that inference is permissible or impermissible, applying the law as set out in Pinochet, which everyone agrees applies. And we respectfully submit, and that is a submission I will be making good on the authorities this afternoon, that an inference that state immunity has been waived in circumstances where that conclusion has to be reached by a process of inference is only permissible where the persistence of state immunity would render the treaty provision odious, or to use the terminology of public international law, would deprive it of effet utile.
I'm sorry, the second part was otherwise odious or...
Odious, or if you use the terminology of public international law, it would deprive the provision of effet
inutile.
Ut res maior. In Pinochet, those of their lordships who would have found a waiver would have done so on the basis that it made no sense to have an immunity that was exactly, and that is the word used in the judgments, coextensive with the offense being created. So they say, but that makes no sense. You're creating an offense which only applies to public officials, and you're saying you have an immunity which will always apply to public officials. That's neutering the provision of any meaning. That cannot be right. Those who would have found for a waiver, and I'm going to show you, that's not the majority, but let's go with that. In NML, as my learned friend has showed you, when looking at the first part of the clause, which Border says is similar to the language of Article 54.1, what does Lord Phillips say? He says, and I'm quoting, that a persistence of state immunity would rob the provision of all effect. My lord, we say that is the test, my lady. And we will look at these authorities together and you will reach your own view as to what the correct test is. But again, in introduction, all I say is it cannot be right what Border is saying in 46.4.1 and 46.4.2.
Can I just mention a concern that I have? I'm still struggling to see why one gets into implication here. So I'm looking at Article 54 on page 2845. It's in a treaty which begins with the contracting states have agreed as follows. So why doesn't one read it? I, Zimbabwe, agree that you, United Kingdom, shall recognise an award rendered against me, Zimbabwe, under this convention.
I'm grateful, my lord, but that is not the implication I'm talking about. You're now still with my learned friend. So I accept that.
Language.
I say, let us accept the premise, and of course I have before that adopted my learned friend's argument, let us accept the premise that Zimbabwe has agreed that the United Kingdom will enforce an award.
Against it, Zimbabwe.
Yes. Right. Let us accept that.
Okay.
And we say, and I was going to come to that after lunch, but let's deal with it quickly here. It's exactly the same as saying Chile has agreed that the United Kingdom will prosecute its officials. That's what we say, and I will explain that in more detail by reference to the Torture Convention. Now, the implication which I say you cannot make is to say, and we say it's a non sequitur, to say that because Zimbabwe has agreed that the UK will enforce, it must follow that Zimbabwe has agreed to waive its immunity.
Right.
That may or may not follow, but the test to decide...
sorry, if I may just pick up on that. Might it not be said that the reason that the waiver doesn't follow in relation to immunity of state officials is essentially that given in relation to exhaustion of local remedies in the LC case at page 1090, that there are some rules of international law that you don't expect to be overridden tacitly by use of general words which apply in other cases. So that would apply in relation to the Torture Convention in the same way as it applies in relation to LC. But here we're dealing with a rule which is directed expressly, as you accept, to the enforceability of an award in the United Kingdom against Zimbabwe. So there doesn't seem to be a separate rule apart from that which this provision is expressly dealing with.
My Lord, with respect, and that is the discussion you were having with Mr. Bastien earlier about the scope. With respect, I think we're in the right territory. Right. But what you now need to do, first we need to identify the test. What is it that normally...
I thought we were agreed that the express language covers our case.
No, the express language, I'm moving on the premise that the first implication is all right. So Zimbabwe has agreed that the UK will enforce. Okay. The implication, the inference, which I say you now need to make is, well, it follows, doesn't it, that it has agreed to waive its immunity by agreeing to enforce.
If you stop it has agreed that UK shall enforce. Why wouldn't one say that it's waived?
Because you need then to see what the scope of that obligation was, which is why I say we're in the right territory.
All right.
And in there, you need to feed in, with respect, two things. One, what is the test? It could be that every time you have a creation of jurisdiction, you abrogate immunity. It could be that. We say that's not the test. We say the test is that unless the immunity is inconsistent with the creation of jurisdiction, it will not take away the immunity. But to answer your question...
What I was seeking to put to you is, might there not be a middle position that the general words do seem to involve a waiver of immunity, but there are some contexts where, because of other important rules of international law, they're not interpreted in that way. And that's what I thought was the effect of Article 31(3)(c) of the Vienna Convention, that you interpret having regard to other rules which apply between the relevant contracting states.
My Lord, yes, but then
But then I'm putting to you, that would explain the Torture Convention cases, and indeed the position in ELSI, and indeed in the ELSI judgment, page 1090, they specifically say, but these general words cannot be taken tacitly to overrule a very important rule of international law. But here, we seem to be, this is the argument against you, dealing with a provision which is directed very specifically in its own terms to enforcing an arbitral award. And there is no other rule of international law to come in by a side wind and say, it wasn't intended to override that.
My Lord, the very important rule of international law, which is at play both in the Pinochet case in relation to the Torture Convention and in this case, is state immunity. That is what is coming in through 33(1)(c). State immunity. You cannot interpret Article 54 without regard to state immunity. And that imports the rule that state immunity will only be waived in an express manner. All I'm saying is that the two are not coextensive. Saying I'm creating jurisdiction and saying I have agreed to waive immunity are two separate things. So you need to draw an inference. And what I'm submitting is that you need, in order to see whether you may draw that inference, that important rule of public international law has been done away with. You need, one, the test, and maybe to come to a more important point in regard to what your Lordship is thinking, the scope of what Article 54 is doing. There is this idea that Article 54 was all-consuming, all-important. Maybe now we look at it 60 years later and we think, oh, that's quite important. But at the time, Article 54 is only being introduced because the convention applies on the international law level to states. But you suddenly have this hybrid form of arbitration where you're going to be able to sue a state directly for sovereign acts. And therefore, and that's what is explained in the travaux, they have to create a mechanism to enforce on the domestic law level. Now, that is important to understand what we are dealing with and how important it is to the scheme of the convention. Because I will again submit that the test is, are you depriving that provision of all effect? And you're not, because as you've already heard, a number of things can happen already under Article 54 itself. You may sue the state in its own courts. There may be a waiver of immunity. And also, you would have already had in 1965 states where you could sue, such as France, as I will show you, where there would have been no waiver of immunity. That's just 54, not rendered odious. But also, the primary remedy would have been that you would have diplomatic protection reviving and could then take your case against the state at the state-to-state level under Article 64. We'll come back to this, my Lord, and I'm very conscious of time. Shall I make my last point? And I'll close. It's my last sentence on this.
We're on well over. I think we'll come back.
No, my Lord, then I will stop here.
Thank you very much. My Lord, did your Lordship say 2 o'clock?
Yes.
Very helpful. Thank you. Speedy sandwich.